Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists and uncertified podcast hosts. In this podcast, we bring our audience of trial and appellate attorneys some news and perspectives they can use in their practice.
And a quick thank you to our sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a CaseText subscriber since 2019, and I highly endorse their service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Jeff, when we started this podcast back in the middle of 2020, and then for the first several months, we recorded episodes that I now refer to as the Rudder Guide in podcast form. And we got about as many listeners as that description might suggest. But then we brought on a very special guest to the podcast, and that guest quadrupled the number of listeners that we got to the podcast. That brave first guest was M.C.Sungaila, and we are delighted to welcome her back today. M.C.Sungaila is a distinguished attorney with 3 decades of appellate practice under her belt. She leads the Buchalter Law Firm's appellate practice out of Orange County in California. MC is a member of the board of directors of the National Association of Women Lawyers. She is consistently ranked among the top appellate attorneys in the state, and she is a leader in the profession, having served in leadership on bar associations and creating appellate clinics to improve the practice of appellate law in the state. Most recently, MC has launched the award-winning podcast, The Portia Project. The Portia Project was recently recognized by the Recorder and the American Lawyer Media International as a finalist in the 2022 California Law Awards for Innovation and Diversity, Equity, and Inclusion. We're so pleased to have MC back on to talk more about the world of appellate law as it looks through the eyes of the Portia Project. Welcome to the podcast, MC.
Thank you so much, both of you, for having me back. I really appreciate it.
Well, we have to. Your podcast, The Portia Project, has just been making waves. We see it's been releasing so many episodes and gotten so many accolades. But we'll talk more about that in a minute. Tell us anything that I missed in the introduction that our listeners should remember about you, and tell us a little bit about what you've been doing in your day-to-day practice.
Sure. Well, I appreciate the introduction. That was very kind of you. Yes, I have been doing appellate practice for a long time, and I continue to enjoy it, so I'll continue to do it. So one thing I really love about my practice is that it's really varied between the courts. I love to do an array of substantive areas, so that's what I love about appellate practice. Each time where the law is developing, we're working in different cases in different areas. So I've had asylum cases in the Ninth Circuit through the Ninth Circuit clinic that I teach at Loyola Law School. I also am working on a brief right now in the U.S. Supreme Court on in the In re grand jury case involving attorney-client privilege. And I'm working on a case in the Utah Court of Appeals right now involving some civil procedure questions. So it's an interesting range. It always is. So you're moving into Utah law. You've mastered all of the California subjects, and now we have to branch out into other states. That's exciting. Yeah, every once in a while I go out of state.
Yeah. Tell us what's new in litigation and appellate practice in California recently, and maybe talk about you seeing any effects of any long-lasting effects of the pandemic? How are things kind of settling down? Are we in for some long-term changes, or are there more changes to be seen?
Yeah, it's interesting. I mean, we're at least at the point where there's a lot more technology in the courts. The courts of appeal, the state courts of appeal, were, I think, really caught flat-footed a bit in the beginning of COVID in terms of oral argument. A lot of them were holding it telephonically for the first few months, which was a little challenging for everyone, I think. So it's nice to have that option, both in federal and state appellate courts, to do that. Most of the courts are starting to come back a little bit, although I've heard that still you can still one side will make a request for remote, and then often that means the argument will be remote instead of live. Which is, I mean, we've gotten used to that a little bit. So we can do either now. We've expanded our toolbox. So that's good. Although in the perfect world, in my view, I'd rather be in person, seeing all of the judges together on the bench, and seeing that interaction. But but we've expanded, and so we're able to do both at this point. I think the question too is something that I've heard from some of the podcast guests from state Supreme Courts in other states, is that they're, especially chief justices who are interested in the overall administration of their court system, is that they really had a wake-up call from COVID in terms of access to justice, having things be more available online, having more hearings available to be done remotely, especially for those who are representing themselves, but I think also for counsel, represented parties. And that is something too, where I think they were a little bit surprised about how much people were using, off-roading outside of the public system. So that was something that was a surprise to them. I think they hadn't realized, jams and other alternative service providers are pretty, they're pretty robust, and they've been robust for a while, but really seeing that impact, because I think that especially in the state courts, the amount of work that was going through was just, cut in half. I mean, criminal cases were not proceeding, civil cases really weren't. People were either settling, going to arbitration or mediation, finding some way to resolve their disputes. And they saw that, they thought, oh, well, when we reopen, we're going to have this massive it's going to be really busy. But a lot of people had resolved it in different ways. And it was kind of like, oh, we have competition, basically, which is how some of the chief justices have told me. Like, we have competition to the public court system now in these private, mediation opportunities. And we need to show up for people. Like, we need to think about that. It's interesting to hear them say that so plainly,
Did you notice
I'm sorry, go ahead, Tim.
Did you notice a surge in references to pro tem judges? We used that once or twice to have we got a reference by the presiding judge of Los Angeles Superior Court to have a pro tem judge, a former LA Superior Court judge, as it happened, to preside over a trial in the early months of the later months of the pandemic of 2020, when we realized that we were not going to get a trial anytime soon. And we used that pro tem reference, and it was very successful in order to get our trial heard. Oh, you got put on mute there, MC.
I know. Hold on 1 second.
Okay, there. Notice we had a little bit of a interruption from a canine friend in the studio today.
Yes, exactly. So
I
think the Chief Justice too has indicated, just recently she said, oh, we're going to have retired judges and justices available as mediators themselves, within the Superior Court system and otherwise. I think that's also a recognition of the usefulness of that, and that they want to, be competitive in that way.
Interesting. We were talking about the use of Zoom and technology by the courtrooms, and one of the issues that's erupting here in LA, where the three of us practice, is
court reporter availability,
shortage of court reporters. And the fact that it's not a problem that could be fixed by throwing more money at court reporters. There just aren't court reporters to report all the hearings, and whether or not the courts are going to change their attitude, or maybe the legislature will change its attitude regarding electronic recording of hearings. Do you have any thoughts about that and where the courts might be going?
Yeah, I mean, that's a true crisis that's erupting right now. The courts are acknowledging it, and we as appellate attorneys are like, oh my gosh, you don't have a record? This is terrible, right?
Yeah.
So, it's a real problem. But there's always been a tension, and it's largely been from court reporters themselves, or the unions associated with the court reporters that have always lobbied against allowing recordings. So I don't know where that's going to land at this point. It's always landed against automatic recording and making sure that court reporters, are able to report. But I don't know how you how you address this situation, which is really at an acute level right now.
Yeah, for our podcast, we use AI and software to create transcripts of our podcasts. It's not that hard to create a transcript or to correct it if there's issues. It'll be interesting to see what my prediction is. There are certain departments like family law, writs and receivers, and like where domestic violence issues are heard, where a lack of reporter is going to come back in terms of settled statements being needed to be settled and doubling the workload on the court. And those particular courtrooms, I suspect, will drive the legislature to solve this problem.
Yeah, well, and there's a deep access to justice question there, because in family law, you're talking about a lot of people who are self-represented and may not have a lot of money to get, to have the court reporter there and all of that to begin with. So the recording, that's a whole other issue.
Yeah. I just so happened to have been recently pouring through the legislative record back from the 1992 AB 2937 bill, the one that got killed, to that would have reenacted the electronic recording statute, and most of the opposition was as he mentioned, fueled by the court reporter lobby, but there were a lot of letters written by judges who said, I don't want to have to manage putting new tapes in, taking tapes out, labeling the tapes, running them back when someone says, can I have that read back? Then you have to rewind it and find the spot in the tape. And it was a big hassle. But now that we've all proven, this is 30 years ago now. And now we all have shown that we can have full trials over Zoom with microphones, with cameras. We'd show that we've overcome the equipment problem, and obviously this is not a funding problem anymore. We have the money. It's a question of availability, and so I think the technology is up to snuff now, and we don't have that labor issue. Apparently, is not an issue. So it seems like something's going to have to be done at the legislative level.
Yeah, and like I said, that access to justice concern is pretty acute for the courts too, and they see that and they want to be responsive to that.
Yeah. All right. Well, without further ado, let's talk about the Portia Project. Now, MC, the last time we talked, we discussed your commitment to training up the next generation of appellate attorneys, including through your firm's appellate fellowship. The Portia Project that you have started takes that to the next level. It shows how women in the law have taken the next step to become trial and appellate judges. Tell our listeners a little bit more about the Portia Project, how you got the idea for it, and how you got it started.
Yeah, so originally I had started work on a book of interviews and the stories, the paths to the bench of women appellate judges around the country. And so I had done a few of those interviews and turned them into, essays and things like that, working with the judges. And the reason I decided that I wanted to do that, and the reason that the publisher was also on board with it, was that there's not as many women appellate judges as you might think in the country. At both the state and federal level, there's, maybe 130, 140. There's not a lot. So there was enough to, highlight in a book and not be too overwhelming. And also I thought it was a good way to encourage people to consider to apply to the bench themselves, and see the various paths that people have taken. Because I think that some people will disqualify themselves from applying for the bench at the get-go because they think, I don't have the perfect background. I wasn't a prosecutor, I wasn't this, I wasn't that. And what you see going through all of the history of everything, even when we thought that was true, it really wasn't. People have so many different varied backgrounds, and they bring those with them to the bench, and there's value in that diversity of experience also. So that was kind of my initial goal. And then in doing the written project, I found that actually it was really fun talking with them. The judges wanted to talk, they wanted to have conversations, and then we turned those conversations into, written products and essays. And that took a lot more time than I initially thought would happen for each interview, a lot of back and forth. And I also thought that it lost something in the translation, that having that conversation, having that very sort of personable showing by each of the judges during the conversation, you got a better sense of their personality, of their approaches to things from the conversation than from a written product. which ended up being, neatly polished and all of these things, but you didn't get the same sense from the conversation itself. So I kind of shelved that project as a book. And then during COVID, I started thinking about, maybe it could be a podcast. And then I hoped for a while that somebody else would have this idea and do it, and I wouldn't have to, but nobody did. So I thought, okay, well, first, you can't have a podcast unless people are willing to talk to you. So I reached out to about, I would say 15 people initially, if they were willing to participate, trailblazing judges, people who were doing, significant work in public interest or other areas. And they all said yes, which was very kind of them. And so we recorded those, and I thought, well, maybe they'll just be like the 15 and that will be it. But what happened was that each person really enjoyed doing the interview, thought it was valuable both for themselves and some self-reflection, but also that it was a valuable project for women lawyers and law students, and maybe even those maybe thinking about law school. So they would immediately say, oh, Judge so-and-so, I recommend her and she would really enjoy doing this. And so the guests would immediately start connecting me to future guests. And I know enough from my legal training, just never say no to a judge, and just, be very respectful of all. And it was such a great opportunity. I mean, at that point, I felt like the mission of the podcast is, something more important is happening here. I'm just the shepherding source of the podcast. And I'm going to carry it through as long as people want to do it. As long as they see value in it, I'll carry on. So, and then along the way from that it got much broader to trial judges, all different kinds of judges. I thought, if I'm applying to the bench, it would be helpful to know becoming a judge is very different depending on which level of court you're at. How you get there, whether you're appointed or elected, varies from state to state. So I thought there was kind of like a civics lesson in all of this as well about how the judicial branch is selected. And then I thought, well, if I'm in law school, I remember that I didn't really understand all the different things you could do with a law degree. And so I thought it would be a good career resource too. So I started reaching out to all the ways that women who are leading and off the bench in a bunch of different ways too, women managing partners, women who are chief legal officers or general counsel, women in government in different ways, whether it's elected office or serving as clerks of court or working in a policy position in the government. Just a whole array. People who are writers now, non-legal things, leading museums, just a number of different things. I thought if people knew all the various ways that the legal training was useful and helpful in their careers, maybe they might go to law school. They might not, They might say, I don't want to practice law or I don't want to be a judge, but that doesn't mean that a legal education isn't valuable.
That's one of the things that's so it's such a feel-good, recurring feel-good moment in listening to the Portia Project is that there are so many different varied paths to the bench, and the Portia Project guests are not limited to women on the bench. There are also prominent women litigators and law firm owners, and these are people that you would assume had it all mapped out from the start. That they were valedictorian of their law school, they were editor of Law Review. They did everything right. They aced everything they ever did, but that's not necessarily the case. Some of them got into, didn't get into their dream law job, or they didn't get the clerkship but at some point they decided, I'm not meant for mediocrity, or just why not take that shot? They'll go in and get that elected seat for judge. Or,
right.
They make those connections and they wind up getting the appointments anyway, or they go start their dream law firm job, and it's outside of the big law model. And so it focuses on all these types of stories that challenge, that point to challenges that are specific to women, like workplace discrimination or harassment, or the special challenges of family. But many of the stories are just challenges and failures that are universal to attorneys, people who are maybe jaded. They got their JD, their law degree, and then it wasn't all it was cracked up to be. What are some of the stories that stand out to you as being, inspirational?
Yeah, I mean, I think they're very human stories. I really appreciate that they're willing to be vulnerable enough to share that and to to show their humanity as well as what they've succeeded in accomplishing. I think one of the larger stories that really struck me personally, because I hadn't really realized, I mean, I feel like very, very blessed to have started my legal career when I did. If it had even been 5 years earlier or 10 years earlier that I went to law school, the amount of opportunities that would have been available to me would have been much more limited. I really didn't realize what a watershed moment the early 1980s was for women in the profession. The appointment of Sandra Day O'Connor to the U.S. Supreme Court was really impactful. It caused a lot more women to be appointed to state Supreme Courts as well. And it really helped open the floodgates for women in law school. And so listening to some of these stories, I was really kind of shocked that it was so close in time. Like if it had been the late 1970s or early 1980s, I would have had the experience that a lot of these judges, Supreme Court justices and trial judges had coming out of law school. Like Chief Justice Durham of the Utah Supreme Court, who was told, men on law review need only apply to these particular positions. I mean, that was just how they put their ad out. And so certain things were just not available to women to try. And we think about that as being so far back in time, but it isn't really. I mean, we're talking about like a lot of progress in 50 years. And even some of the judges in California who said, yeah, mid 1980s, early 1980s, the judges were a little concerned to hire women as law clerks. Big law firms in Los Angeles would say, well, we'll hire you for a couple of years, but there's no way you're going to be in a partnership track and you're not staying here. And to think about that now, like, wow, that never happened, when I graduated in the early 1990s. So a big change in that time frame. And so I thought, that was very impactful to me because I didn't realize how close it was in time. I think of it as being further back. And I thought if I didn't know about that, certainly the current, the new generation doesn't know anything about that. And so I thought, while it's a little depressing to hear about that, it's also really uplifting because people who experienced that as an entry point to their careers ended up becoming state Supreme Court justices nonetheless. As you pointed out, Tim, they found a way, right? So that's pretty exciting. If they can do it and you don't have those same entry barriers in the same way, then what can you do? Like there's so much more that people can accomplish and to be, see that as a positive change. So that's one thing that really struck me, how much has happened and changed.
Right. Hey, you've said often that your heart is in pro bono and public interest work, and you've obviously flourished doing that in a big firm environment. And the podcast showcases attorneys who've managed to do pro bono and public interest work outside the big firm model. That was surprising to us. Did that come as a surprise to you to learn of the attorneys who have managed to do public interest work under their own shingle, or were you aware of that secret and wanted to use the podcast as a way to kind of let the secret out that you can't do public interest and pro bono work outside of the big firm context?
Yeah, I do have a deep interest in public interest and impact appeals in particular. I think for two reasons. One is that's how I was raised in terms of service, that you find ways to serve with your skills that you have. And especially appellate work, you can make such a difference with one case. That case can be helpful for the client, but also for so many others in setting precedent. So there's a special role, I think, that appellate pro bono can play, and not as many people who can do it. So I feel that sort of obligation, responsibility in that regard. I do intentionally highlight public interest lawyers and those who are doing important work in that regard in a bunch of different contexts for two reasons. One is I want to show the array of places in which you can do that work to law students so they're not too narrow about it. And second of all, because I want to encourage other attorneys to learn about, in particular, the organizations that do this and to perhaps volunteer their own time pro bono, to carry it forward and to do more of that work also. So those are sort of two of my goals in doing that. And there are really great, just great public interest organizations doing interesting work. We've had human trafficking organizations on. We've had, of course, PLC here in Orange County, which is just so well known for so much of its public interest work in so many areas, and which was actually founded by the Orange County Bar Association. So that's kind of an interesting thing. Just like Public Counsel in LA was an outgrowth of bar work. So there's that. And then Family Violence Appellate Project, which does important work in the family law arena and domestic violence arena in California appellate courts. So I just try to highlight really all of those that I think are really interesting that people should know about the areas in which that work is being done. And as far as doing pro bono work as a private lawyer outside of a big firm, I think that's mostly what we think about is big firm work, but that's not exclusive. I mean, I could think of one person in particular, Harmeet Dillon, who has her own firm, her own boutique firm, but then she founded her own nonprofit to do work that she thought was important in the public interest arena too. And she has such a amazing story in her podcast episode. She's really very frank about her personal life and personal challenges as she was going through law school. And she's just an amazingly strong person when you hear that story.
Yeah, that made for a very interesting episode, hearing about her, how she set up her shop and realized, she was doing the work that she wanted to do, but how do you get funding for doing this public interest work? Well, you can just give it to my client, but that's not ideal, obviously. So maybe I set up this nonprofit, and she hired ethics attorneys and tax attorneys in order to do it all right. And I thought, wow, that's a smart cookie.
Yeah, exactly. Well, and I think it's interesting. I mean, I think she and I share that same view of like, well, okay, let's get something done. How do we do it? We don't know, but we'll figure it out.
Yeah. Well, on that subject of, the guests on the Portia Project are not just women who have landed on the bench, but have used their JDs in other ways. And that's kind of a recurring thing in the Portia Project, is that a JD, a law degree, doesn't just mean one thing. If you don't find fulfillment or your first job or your second job or even your third law job, then maybe it's time to broaden your horizons. And MC, one thing I've learned about you that you've talked about on the podcast is you learned that through your kind of distaste for cross-examination, that taste for blood and drawing blood out of a cross-examination witness, that wasn't for you. You liked the area of appellate law a little bit better. It was more to your taste. I wonder if you could tell us some of the unexpected, some other unexpected career paths that your guests have taken, even if they winded up on the bench, maybe they took a winding road to get there that you found interesting.
Yeah, I think I think you were referring. I'm not the only appellate lawyer who has said that, had that same kind of story, that the thing that made us realize that we were not trial lawyers and we better find something else to do with ourselves was that we felt badly for the witnesses when they were being cross-examined. And we're like, whoa, that's very different. That's like a different kind of beast than trial lawyers. They have a different view of that. So apparently there's more than just me that had that kind of epiphany about going into appellate work.
That could make for an interesting personality portfolio of the different personalities that make for excellence in different areas of the law.
Yeah. I was just like too kind, to people, even people who may not have been truthful.
Yeah.
So I just couldn't do it. But I love talking to judges. I mean, from my clerkship, that's what I was used to doing. So it worked out well. I think there's a lot of twists and turns to all careers, and that's another thing. You think, like, you see the end result, you see where someone ends up, but you don't often get to see like all of the meanderings that eventually got there. And afterwards, you look back and you go, it makes total sense that I'd be in this position given all of my experience in these other roles. But at the time, it wasn't clear at all. So it's interesting to hear those stories, but where people have gone with it. I mean, I can think of Patricia Hunt Holmes, who was one of the first women partners at Vincent & Elkins in Texas. And then when she retired, she became, she started out with a PhD and then was in academia. Then she went into law. And then she decided she had enough experience to write, to have meaningful books that she would write at this point. And now she writes kind of at the intersection of law and fiction to some degree. There's reality to all of her stuff, but being novels about young women in big firms and navigating big firms, but there's always like a murder mystery part of it. And she did one on human trafficking, which was a human trafficking victim story, but she used it to highlight how much her city of Houston, Texas was really a hub for a lot of trafficking, and to get some traction going in the community to be proactive about it. So yeah, that's interesting. And then there's some people who have ended up becoming, which is really something I don't think people think about, being museum directors. So people who have run legal nonprofits, then moving to just a nonprofit sector. So like Jessie Kornberg, who runs the Skirball Cultural Center in Los Angeles, she was previously leading Bethsatic, legal organization, nonprofit in LA. And then prior to that, Ms. JD, which is now really well known for women law students and new entrants, women entering the profession. So there's that. And then Jessica Aronoff, who ran Break the Cycle, which was a teen domestic violence organization. And then she moved to foundation work, working for a private foundation. And then from there, now is leading Keaton Children's Museum in Santa Monica. So it's interesting. Also, it's interesting to hear a lot of them be very conscious about how their training and the things that they've learned are very helpful for them in their current roles. So like Jennifer Friend, who runs Project Hope Alliance for homeless kids here in Orange County. She was a big law partner prior to becoming the director of Project Hope Alliance. And she's the most intentional about saying this, what I used from my cross-examination, what I used from, organizing litigation and leading teams. And here's how I use that now in board meetings, or to persuade donors, or to work on coalitions. It's really interesting to hear someone be that conscious of how their legal training is helpful in a different setting.
Yeah. And you recently had Molly Dwyer on your podcast, the clerk of the Ninth Circuit Court of Appeals, and I remember she said something to the effect that she realized she was a better organizer or manager. Her organizational skills are better maybe than her legal skills, or she at least enjoyed doing that better. It made me think of MC. You and I were at an awards dinner recently where Presiding Justice O'Leary of the 4th Court of Appeal was accepting the Sills Award, and retired Justice Aronson was there complaining about how Justice O'Leary had once called him a, quote, crappy manager. And all in good nature, of course, but attorneys don't always have the same skill sets. They're all, they could be excellent lawyers, but there's a lot more that goes into the legal industry.
Yeah, I think there's also a lot to learn from the people who are in different roles, like the clerk roles. I don't think you think about that a clerk is often a lawyer. You don't think about that. So thinking about that as something that might be something you would want to do down the line. The other things, I think a lot of the guests who are in the business world, so CLOs or general counsel, they have a different view of how they made different choices in their career, maybe more intentional from the standpoint of what kind of skills they wanted to acquire and where they could get those, who they wanted to work with, like who they wanted their boss to be. If they were a deputy in the legal department, was the GC someone who had particular leadership skills that they thought, maybe they had a gap and they wanted to learn those, and they thought this person was particularly good at that. It's interesting to hear that kind of thinking, because we don't think that way organizationally within law firms exactly the same way. So it's interesting to hear those stories about why people made certain career moves. Right.
Okay, MC, you've now interviewed over 100 judges and prominent female attorneys, and you've extracted all their secrets of effective advocacy. So now, tell us the secrets. when you ask your guests their tips on how to persuade, what are some of their most common answers? What are some of the answers you found surprising? Maybe let's start with brief writing tips.
Yeah, I was thinking about this. There are so many discrete tips that I think we've heard a lot, especially at the appellate realm, in terms of, some judges read the reply brief first, or they read all of the tables of contents across the briefs, and so make sure that those are clear and helpful for them. Don't write too long. Even if you have 50 pages, don't use them all. If you can use them less, choose your issues carefully. They don't want to see a dozen issues. 3 to 4 issues is fine. All of that I think was fairly consistent. I think that there were 2 things that stood out to me, like overall, if you listen to all of those discrete comments, what is the overarching difference or difference in perspective that the judges have? And which I particularly asked, like Patricia Millett on the DC Circuit was one of the, really most well-regarded U.S. Supreme Court attorneys prior to joining the bench. And she was, terrific. So I really asked her in particular, was there something you learned? Like if you were an advocate and you knew what you knew now being on the bench, what would you do differently, as an appellate lawyer? And were you surprised by anything? And I think what she said really kind of encapsulates what I think the overarching view is that's different. And that's you as the advocate are looking for an outcome and we're looking for an opinion. And that means so many things. Like we want to know how to write the opinion, both in a way that fits this case, but we're also thinking about the larger body of the law. Are we going to disturb anything if we write this a different way? And so it's actually really helpful to have you tell us how we should write the opinion, like be more intentional about that, because that's what we're looking for.
Yeah.
That's where we need help, right? And then also I think the other part of it is this sense of obligation, of responsibility to the rule of law and to the law itself, that it comes out in different ways that we talk about frequently at the state Supreme Court level, which is, hey, I'm not just deciding your case, I'm deciding this legal issue for so many other circumstances. And I want to make sure we don't decide it in a way that is not something we saw coming, in some other setting. We want to make sure we've considered this rule as a matter of policy, practicality. It's a good rule, not only for this case, but for other settings too. And that, I think, is part of this same kind of, we're looking to write an opinion. We're looking to write an opinion that adds to the body of law. And so we think about that in so many different ways. We see it as advocates in terms of questions like, well, yes, counsel, I know these are the facts of your case, but what about this hypothetical? But that's just like the tip of the iceberg in terms of how the appellate justices are thinking about it. And then also, I think the role of oral argument. I think so much we think, we'd like to think it makes a difference, but probably, maybe not in the outcome in so many cases. But particularly in courts where there isn't a conference before argument, I've heard over and over from the justices that they are prepared. They're prepared, of course, to go to argument, but they consider argument part of their preparation to the decision making too. They want to hear what their colleagues are asking. They want to hear what the lawyers have to say, and they try very hard to keep an open mind during that argument. And part of the decision making to them is hearing the back and forth, hearing the other questions that their colleagues ask, which might actually raise things that they hadn't thought about prior to argument. So even if it may not, in the end, end up, as far as we can see, as the advocates, making a difference in the outcome, their whole approach to it is with that, sense of, as the advocate, you have to be 110% prepared by the time you stand to the lectern and know, the outcome you want and all of the different questions. But oral argument, those on the bench, is one more part of that preparation to writing that opinion, which is their ultimate output. So they just have a different attitude towards that. And that's something that I've heard over and over in different ways from different appellate judges. So I think just being aware of that, like, what are they doing? Like, in a very practical way, what is their job and what are they focused on? What are they concerned about? I think that in itself will really impact how we do our job. Like, how are we going to make their job easier? You know, there's a lot of discrete ways, but I think keeping that in mind will really impact the decisions you make as an advocate.
Yeah, you said a couple of things that I think are really next level thinking, and I think it really goes to what makes an appellate attorney different. We talked about so you said that from the judge's perspective, they're thinking you, the advocate, are looking for an outcome while we are looking for an opinion. How are we going to frame this opinion? I think that's subtle but really significant. It kind of reminded me what we were just talking about a few minutes ago about as trial attorneys, as really effective trial attorneys, you want to just gut that witness when you're cross-examining them. And so if you ask that same attorney, well, what do you want on appeal? Well, I want to bury my advocate and I want you to help me do it. You know, I want you to say that their arguments are bad and they should feel bad. Well, no, we're not going to issue that kind of opinion. So you need a different kind of perspective, a different kind of advocate to help us get where you want us to go. Exactly.
Yeah, I think it really defines the difference between trial and appellate lawyers too, because we're conscious of that in a different way. It's focused on the law and the direction of the law, and you know, making the court comfortable with this decision, not only in this case but in other settings.
It's
the other part that I've gotten sort of confirmation on, which it's always been my view of what we're doing as appellate lawyers, and I think about it consciously this way every time, which is we have a case, which to me is, or a client, which is to me is like, you know, a pebble in the stream or a boulder in the stream, depending on how big the issues are, and we're looking to place that in this stream, this river or whatever that's going by, and we need to have an explanation as to why the boulder goes there. Like, why does that make sense in the stream of the law? And if it changes the direction of the stream to do that, we need to have a good explanation as to why that's okay and why that's where the stream should have been going all along or something like that. And that to me is always that conscious in the background of we're part of something bigger. Our case is part of something bigger, and that's something that the justices are conscious of too. And that's kind of what I keep hearing from them, is we're conscious of that. We're very conscious of that about what we're doing. We just don't want to kind of do no harm with the law in the bigger sense. And in fact, this stream analogy, I've run it through with a couple of different judges, and many of them have said, yeah, that's exactly how I think of it. It's exactly how I think of what we're doing.
Yeah, that's an excellent metaphor. I love that. And then the other thing that you said that I thought was really interesting about oral argument, that justices will consider preparing for oral argument as part of their preparation for writing the ultimate opinion. And it reminded me, I was listening to one of your episodes talking about the subject of oral argument, and you and I we discussed this the first time you were on the podcast about oral argument, and I had voiced the view that, well, for some cases where the economics don't justify it, preparing for oral argument is a big deal, because you have to review the entire record, review all the review all the arguments and issues, be prepared to answer any question about any argument or anything in the record. And that's a big undertaking. You don't just show up. And so sometimes I might think about suggesting that my client waive oral argument, and you said, no, I can't imagine ever walking away from an opportunity to give the justices that one last unique glimpse into the case, to understand the arguments if whatever I said didn't work the first time. And I was reading an article, one of Justice Bedsworth's columns, where he was making my pitch. He was saying, ironically saying the same thing that you just said. It's so hard. We undergo so much work to prepare for oral argument. Won't you spare us, advocates? Won't you spare us every now and then by just waiving oral argument? And then we had Justice Thompson on, who said, I can't imagine anyone ever waiving oral argument, at least show up.
Yeah, he and I are aligned on that for sure. Yeah. I mean, but as a lot of the judges and justices that I've interviewed, they've all said, also, I think there's something that we don't think about as advocates. We see it, but we don't think about it the same way. It's a consensus building decision making at the appellate level. one judge cannot just decide something. If they do, they're in the dissent. So there's persuasion that's going on among the justices with the questions that are asked afterwards in conference. There's a lot of that going on. And so there's a listening that they want to listen to each other and the questions that they ask. And they want to ask questions of the advocates sometimes to get the other colleagues to think about things. We've all had that sense where we're like, oh, we don't think that question's really directed at me. It's really to have another colleague think about something in a different way. But all of that process that we're all part of that process, all of the judges on the bench and the advocates, then you see the value of argument in that way as well, because it's a prelude to their sitting down and conferencing and thinking about issues. So the questions the colleagues ask are just as important to a lot of the judges I talk to as what the advocate says.
Yeah. Well, and then going beyond the tips and tricks that you can get from listening to the Portia Project podcast, MC, you've said that what you get out of your interviews for the Portia Project is to know about the human being behind the robes. And many in our audience are busy trial attorneys. Why should busy trial attorneys pause to try to get a glimpse and an understanding of who that person is beyond, underneath the robes?
Yeah, I think there's something. Well, first, in what we were discussing before, I think it's interesting to understand their perception of the process, of their role in the process, and their perception of decision-making process, the oral argument, and the process with each other of, interrogating the advocates and then persuading each other with regard to decision-making also. I think all of that's helpful just to have an understanding of that. And then where someone comes from. I think that there's so much interest in, having a diversity of experiences on the bench. And some of that is because we're saying, hey, someone who was a prosecutor, or someone who was a public defender, or someone who was a civil litigator, they come with different understandings of how certain areas of the law work, and they can share those with their colleagues. And it can impact their decision making. So I think it's important as an advocate to understand, hey, where did these people come from professionally, personally? What kind of challenges did they experience? What kind of empathy would they have to different situations as a result, like a very personal level of empathy? Justice O'Leary, who you mentioned, she has such a deep experience on the trial bench and as a presiding judge on the trial court, that, she said when she thinks about just writing opinions, she's very focused on being clear. She's not just telling this trial judge what you need to do now if we're remanding it to you, but she knows that all of the colleagues on the trial court are going to be scratching their heads and reading the Court of Appeal opinions to say, well, what should we do in our case? So because of that background, a deep background on the trial bench, she's thinking about that when she's writing opinions. How can I be clear about what this disposition is? So when you say, is it important to understand, someone's background? It's like, well, I think that background plays a lot into, and she's very conscious of this in what she's doing when she's writing opinions and how much direction she's giving to the trial judges.
Yeah. Okay, one last question before I turn it over to Zeus for our special lightning round. MC, you said that when you first started the Portia Project, your ambition was to capture on record the approximately 130, 140 female appellate judges throughout the country. It sounds like you're getting close to that goal. Do you intend to close the book on the project once you hit that goal, or what's next after the Portia Project?
Yeah, so I do. I really, we have a lot of great participation by state Supreme Court justices. So by spring of next year, we will have, voices, sometimes multiple voices of justices from 32 states Supreme Courts, in some cases 2 or 3 justices from certain courts participating in the Portia Project. So I'm very excited about that level of participation. And the federal courts are also getting involved, the federal circuit courts. And I hope that some of our U.S. Supreme Court justices will also participate at some point, and more state Supreme Court justices. So I'm hoping that there'll be even more participation there, but also in the sort of wide array of things that you can do with a law degree. If there's something else that comes to me that I'll think of. We have legal design people, which is a new movement in approaching to contracts and a bunch of other things. We have international. I have a episode with international legal design experts, legal tech founders of all kinds of different companies, which is something that we all is helpful to learn about. So I don't know. I think that when I reach a certain level with regard to the number of judges participating, I'll reevaluate exactly how much more we'll do.
Yeah. Okay. All right, M.C.Sungaila, we're going to take you off now to a special lightning round, and I think you'll find some of these questions familiar because some of them are lifted from the questions you ask your guests on the Portia Project. I'm going to turn it over to Jeff to administer.
Yeah,
Oh, no.
Saturday Night Live, when they have return guests, they get a special red jacket for return guests.
Right.
You get invasive questions. So
I think
buckle up.
about it now. I'm preparing, I'm like looking at these questions. I'm like, yeah, these are kind of tough. And I do this to my poor guests every time. I'm going to be a little more empathetic to them. Yeah.
You'll get no such empathy from us.
Yes. So, MC, what talent would you most like to have?
I would like to be able to play the harp or to plein air paint.
Oh, all right.
Those are pretty
very good.
specific, but yeah. Mm-hmm.
Yeah, but doable.
Yeah.
I don't know about the harp. That seems hard.
Come on. With YouTube, you can learn how to do anything, given enough time. What trait do you most deplore in yourself and others?
Okay, so I think they're a little bit different. So in others, I really deplore like meanness and treating those people perceive as being lesser than them or lower in some way with disregard or disrespect. So those things kind of bother me and kind of tell me about someone's character. In me, I wish that I had a better sense of time. I do a lot, but I always think that like whatever task, that'll just take a couple hours, and it always takes more time than it does. Yeah. So that I wish I were better at estimating that.
That is my Achilles heel in time blocking.
Yeah.
Yes.
Absolutely.
Yep.
Absolutely. And who are your favorite writers?
Well, I'm super eclectic. I have hundreds of books in my home and in my office, probably more than I could ever read. Although I understand from Nassim Taleb that that's a good sign that you have this, sort of level of humility. You can never learn it all or never learn everything. So I hope that's good. Otherwise, it's just a ton of books that I may not end up finishing. But I really appreciate particular types of writing. So turns of phrase and artfulness with language. So, and storytelling too. So I would put in that category Nancy Packer, who taught at Stanford in the creative writing program. She didn't write that much because she taught students, but she has a couple of books of short stories that are like the most tightly, beautifully written stories in that genre. And then Brian Doyle's Mink River. I don't know if you've read anything by Brian Doyle, but he is a really wholly unique storyteller and just a beautiful writer. And Jhumpa Lahiri's Interpreter of Maladies short story collection. I've always loved that one. And also John O'Donohue, who's an Irish mystic. I really like his writing. It's really powerful. So, yeah.
Interesting. All
right, I like
Tim,
how you noted that these you like these writers for their turns of phrase, and that's something I look for as well. Just even if the subject matter is not entirely surprising, if it's told in a way with unique, arresting turns of phrase, that always sells me.
Yeah. And Tim, I'm going to task you with putting Amazon links in our show notes to those books. So
I'm going to need some spellings on MC.
All right, and who is your hero in real life?
Yeah, that's a tough one because I think I put them a little bit different. I mean, definitely my family, like my mother, my parents, grandparents. I think about my dad, who always like firmly believed that his daughter could do basically anything. And I think about how important that is to having, especially your father believe that and not limit you like, oh, that's my girl child, so she can only do certain things. So I really value that. And then my family, my grandparents came over, many of them through Ellis Island, and did some really, worked in steel mills, did some really hard work so that their children could go to college and do well. So that's pretty heroic in my book.
Yeah.
But as far as law, it's the judges that I worked for, the 3 judges, and the dog who just had a fight. Hold on a second.
Yeah. Okay. And what person, living or dead, would you invite to a dinner party?
Okay, so this one is super eclectic. I was trying to like narrow it down to one person. And I'm like, no, I'm just going to have a whole party. I'm going to have all of these interesting people and have these discussions. So I was like, okay, the Queen of England, she would be pretty cool.
Yeah.
Winston Churchill, Sandra Day O'Connor, Ruth Bader Ginsburg, Thurgood Marshall, Professor Victor Hansen, he was really interesting historical perspectives from Stanford. Law professor Larissa Litsky, who's a friend of mine, but also is a really interesting thinker about First Amendment law. And my parents, my judges that I worked for, and also some podcast guests who I really, really like and would love to have dinner with at some point. So the former Missouri Supreme Court Chief Justice Ann Covington, Washington Supreme Court Justice Raquel Montoya Lewis, who was a tribal judge before she became a trial court and Supreme Court Justice. So she has really interesting perspectives. And then who I mentioned already, DC Circuit Judge Patricia Millett, who's just really remarkable.
Yeah. Yeah. The IQ points represented at that dinner table would be staggering.
Yeah. And the final lightning round question, and Tim, I'm going to suggest maybe we rename this not the lightning round, but the final lightning round question is, do you have a motto for life, and what is it? Maybe.
Yes. So I think I have a few, and that is echoed by my dog. So 2 that I aspire to, which is really like my mom's, that she gave to me. Hold on a second. Yes, he had a bone, and that didn't help either. So mottos for life. So I think there are 2 that I aspire to, which is really my mom's, that she basically tells me every day, which is make this the best day ever. And also that every day is a new canvas, paint it the way you want. And I think about that as like starting over and being fresh, and like whatever happened the day before, if it wasn't great, you have an opportunity to start fresh each day, and to take that with a lot of grace and humility. So pretty simple sayings, but that's how I look at them. And what I actually engage in without having to aspire to or think about, I think is be kind, never give up. And if there seems like one approach is a dead end, or it ends up being an alley, you just back out of it and go somewhere else. Find any way. If there's a wall, just find a way around it and
keep at it
and persist.
Yeah.
Okay.
I love
that's
it.
great. Well, you survived our patented lightning round, and perhaps we'll send a one-of-a-kind limited edition mug your way as a thank you for coming on the show and surviving the lightning round with us.
Awesome. Thank you so much. I feel blessed to have survived.
Yeah, the turnabout lightning round. MC's questions turn right back around on her. And if you'd like to see those, hear those questions put to over 100 judges and prominent women attorneys, tune in to the Portia Project with M.C.Sungaila.
Right. And as we wrap up this episode, I do want to share a bit of sad news. Just before hitting record on the podcast today, I learned that Judge Judy Churlin, formerly of the Los Angeles Superior Court, had passed away. Judge Churlin was the judge in the first trial I had over 20 years ago. She had a big impact on me early in my career, and I'm sure I'm not the only lawyer who will miss her presence and wisdom. So I just wanted to share that sad news.
Yeah, thanks, Jeff. She had a major impact on women lawyers in Los Angeles, and also a lot of impact in her work with the Western Justice Center Foundation, which was started by Judge Dorothy Nelson on the Ninth Circuit.
Yeah. And with that, MC, thanks so much for joining us. That wraps up this episode. We want to thank Casetext for sponsoring the podcast. And each week we include links to the cases we discuss using Casetext, and listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP. And also look for links in the podcast to Amazon to all of the books that MC listed that Tim's going to find.
That's right. And if you have suggestions for future episodes, please email us at info@calpodcast.com. And please tune in for future episodes for more guests, cases, and news. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.